The honourable member for Toronto-Danforth.
Thank you, Mr. Speaker, and I should indicate at the outset that I'll be sharing my time with my colleague, the member from St. John's, Mount Pearl. I'd also like to address briefly some comments from my colleague across the way from Oakridge's Markham and ask that he do his best to not take the word of whoever's feeding him misinformation. On the day that the bill was tabled, I appeared before the media and I said that I was reading it. I had not yet read it all, but I had read enough of it to be extremely worried about where it was heading and indeed whether it was going to structure things in a very unfair way, and I asked the media themselves to be on the outlook for the details. It was the next day that I came out against the bill after many hours of reading it. So what my colleague has been fed by way of a line is completely inaccurate. I'd like to address our motion rather than the generalities of the bill. We already had an initial second reading debate on that, and I want to put in the context of our request for cross-country hearings to be part of the Procedural and House Affairs Committee study, that there have been no public consultations in advance. We have a debate with the Minister about how much he consulted at all in advance, especially with Elections Canada, and we believe, listening to the Chief Electoral Officer, that that did not take place. Certainly there was no consultation beyond a hi-hello session with the critics or the other parties. So it's all the more important now that we consider the public input side in something as fundamental as this piece of legislation. It's hard to characterize the Canada Elections Act as anything other than one of the most fundamental statutes in our system without at the same time being constitutional. You can't get any more fundamental without being a constitutional document. It's also all the more crucial because tradition and convention has been flouted in the context of this bill. In the past, it's been very much the case, majority government or not, that all parties, and including opposition MPs who may not belong to parties, but all parties in particular, are involved in some kind of a inclusive way before a bill hits the House, in order that there is some degree of consensus and buy-in on changes that by definition should be consensual and nonpartisan. That's not what's happened here. All the more reason that this government and the minister needs to be woken up to the concerns that those of us who've had a chance to read the bill have been raising, and that day by day, week by week, more and more people are becoming concerned about, which will only be fully apparent to this government if the committee is able to have some hearings outside of the bubble, of the Ottawa bubble. And I'd also like to make a final link. This is called, if we had a fair voting system, this unfair Elections Act would never have hit the floor of the House. If we had a system where proportional representation was built in, we would not have a single party running a majority government. It would be rare in our history that that would be generated, because it's so rare that you get 50% of the vote from one party. The circumstances would be very different. The tradition, the convention that parties should be consulted and work together in the Canada Elections Act would have been forced upon this government, assuming it was the government, but with fewer than 50% of the seats. If we had a proportional representation system, we would have had a more collegial consensus approach to how this bill was generated. The concerns that we have, that we've been articulating, debating, I must credit the minister for coming out and continuing to offer his point of view. A lot of that would have occurred in advance, and a lot of the problems in the bill would have been cut off at the knees if the government is serious that it had no intent to do X, Y, or Z. So we've just heard from the minister that the whole question of being able to call former donors is not going to be abused because any calls have to be for the purpose of that. I'd like to hear the minister then say he'd be he will accept now, here and now, an amendment that says for the sole purpose of calling former donors, and that any other aspect of that call would itself be illegal and or part of the campaign expenses. But that would have been sorted out in advance if we had been involved in this at an earlier stage. The minister himself did not bring this up in his speech, but it's been brought up on several occasions by colleagues across the way, which is we don't do cross-country hearings for studies of bills. That's supposedly a truth. It's not a truth. Just in recent memory, C-15, the Northwest Territory Devolution Bill, the relevant committee went up to the Northwest Territories. Why? Because although it's a piece of text and has to be studied as a piece of legislation, the context in which that bill was going to take root was important to that committee. C-10, a bill on firearms control. The committee traveled to Toronto. These were studies of bills. And then when the opposite side of the House says, we only ever travel for policy studies, that doesn't help either, because there is so much fundamental social context involved in the policy decisions made so far in this piece of legislation that hearing from Canadians in their local settings, whether it's Aboriginal communities on reserve, people who are in transitional situations in downtown cities, urban areas, whether or not it's just students on the campus or Canadians who might not otherwise have a chance to testify before a parliamentary committee and are not used to tuning in to CPAC in order to do so, who might nonetheless turn out to a committee hearing just to listen and learn whether or not they're testifying. There are reasons why this bill, as fundamental as it is, and I think the Minister realizes how fundamental it is, needs to be grounded in a broader consensus and buy-in by Canadians at large, quite apart from the fact that other parties were not involved in bringing it forward. And I would also want to draw attention to my colleague from Louis Saint Laurent, who has spoken about the irony that a House committee has traveled as far as the Ukraine to study democracy there, including having public hearings, and yet somehow this is being resisted tooth and nail here in our own country. I have been a harsh critic ever since spending all that time reading the bill within one day, because we had a debate the very next day of the bill. I'm still concerned every one of the replies the Minister has made. I am still concerned that without amendments, those replies don't actually do the job. Canadians can read what I have to say on my own website, and something that I must admit is provocatively entitled, "The Unfair Elections Act is a con game," and see the long list of concerns, well over 24 concerns that I have, that none of which have been obviated yet by any of the arguments the Minister has made, despite his best efforts. So I'm not going to go into those details, but I want to say my current concern has only been deepened, and that's, one of the reasons why. I'm hearing from more and more Canadians, not just experts in the field of electoral law or electoral processes, but Canadians taking the time to have read bits and pieces of the legislation and drawing something new to my attention. Now, if average social knowledge of average Canadians, ordinary Canadians, can produce that kind of feedback to me, my guess is the benefits of cross-country hearings will also produce insights for every member of the Procedure and House Affairs Committee. I want to end, I think I probably only have 1 minute, thank you, Mr. Speaker, with a quote from Jessica McCormick, the National Chairperson of the Canadian Federation of Students, who is in Ottawa and who can manage to come here and hopefully would be on the list for Ottawa hearings. But she gives an example of the effects of this bill that I think you can extrapolate from to say why we would benefit from going around the country, at least as part of prox hearings. She says, quote, and I'll be ending here, "Canada has amongst the lowest youth voter turnout when compared to peer nations. The effects of Bill C-23 will make it harder for youth to vote by complicating the voter identification process and eliminating public awareness campaigns that encourage youth to vote. C-23 serves to cement the notion that politicians don't care about the issues that affect youth. It's our firm belief that the bill will contribute to a decline in voter turnout that the provinces and peer countries are actively attempting to reverse. The decline is clearly a threat to a healthy democracy and must be meaningfully addressed, not encouraged." End of quotation. It's that kind of input that I'd be looking for, not just here on the Hill in parliamentary committee, but also across country, across Canada through cross-country hearings. Thank you, Mr. Speaker.